On November 30th last year, Francis Walsh, a member of the MCK's Legal Services, appeared before the Supreme Court of Canada to make a presentation in a case involving the Enbridge Line 9B reversal. The Chippewas of the Thames challenged the adequacy of Canada's consultation process, and the MCK supported their claim. On Wednesday, July 26th, Walsh, along with Suzanne Jackson, another member of the MCK Legal team, returned to the Supreme Court for the decision. And if one word could describe the Kahnawake reaction to the result, that word would be disappointment.
Well, in a nutshell, the Supreme Court upheld the National Energy Board's approval of the pipeline project, which ended up being a big disappointment for the Chippewas and, of course, the MCK that intervened in support of the Chippewas case. And, we're really disappointed in the court's decision because we had gone there stressing the importance of direct Crown and Indigenous consultation, so really having consultation take place on a nation-to-nation basis. And what the court decided today was that the government of Canada is free to establish boards and implicitly delegate that duty to an administrative tribunal that can carry out the consultation obligations on behalf of Canada, and that board doesn't even have the obligation to assess whether or not the Crown had sufficiently consulted with the Chippewas before making a final decision that could impact their rights. From Kahnawake's perspective, from a legal perspective, we're going to be struggling with the implementation of this precedent. We feel that it establishes too low a threshold or a standard by which administrative tribunals have to operate in assessing whether the Crown has met its consultation obligations. So definitely we're going to be struggling with that decision moving forward and seeing how we can find ways to ensure that the Crown properly consults with Kahnawake on a nation-to-nation basis when these large-scale projects move forward. The representations that Kahnawake made in front of the Energy Board during Line 9B were perhaps limited to things that were directly under the board's purview. Certain conditions that they could have placed on the project. Where the gap is and where the problem is that if Kahnawake had wanted to raise certain issues or recommend certain measures that only the government of Canada could put into place or address, we would not have been able to do so because the government of Canada refused to come to the table and have any direct consultation with the First Nation. So that's where there's the danger of having gaps in the process. So while there were certain successes in having certain issues looked at by the Energy Board during the Line 9B process, everything else that was above and beyond what the Energy Board can do was never assessed and was never looked at. And that's where there's the problem, because there's gaps there. You really need to look at political avenues to address those gaps. We also have an opportunity now because the federal government is reviewing the legislation surrounding the National Energy Board Act, the Canadian Environmental Assessment Act, the Fisheries Act, the Navigation Protection Act. They're doing a comprehensive review of those 4 acts right now, and we are involved in a consultation process on those acts. So there is an opportunity for us to try to point out some of these gaps and try to have them addressed and try to go above and beyond what the standard that's been established by Canadian law is.